Good afternoon, everybody. I have been working in the area of cooperatives particularly, probably more so than mutuals, for nearly 20 years, going back to the creation of the New Zealand Cooperative Companies Act in 1996.
Put this on, please.
You ready?
Yeah.
Okay.
Thank you.
I thought I spoke loudly enough, but no, obviously not. Thinking about that, and in 15 or 20 minutes, what do you say? So this is my attempt. I'm going to talk about two things. One, when we think about legal challenges for cooperatives, I think about it in two ways. One is what's happening out there for the entire economy, or in the legal system, or in changes to regulation, which might have a specific and interesting and different effect on cooperatives. And I'm going to talk about one matter there, the Financial Markets Conduct Bill, which is basically the securities legislation, which is the rules about issuing shares in cooperatives. And the second thing I'm going to talk about is the perennial capital structure challenge for cooperatives and how that works within the New Zealand legislation. The gentleman at the back talked about the legislator being a challenge for cooperatives in New Zealand, cooperatives generally. Well, in New Zealand, by and large, the position is that the legislation is fairly neutral. Certainly the privileges that cooperatives might have had in the past have gone, and now the overall approach is to put them on a level playing field with investor-owned firms. And it goes to such an extent that when the officials are thinking about general regulation, they don't really understand or even think about how general regulation might affect cooperatives. And one of those areas is in the area of securities, which is about when you issue shares to members, what do you have to tell them about those shares? So I'm just going to talk about that briefly and why it's special, why it's an issue for cooperatives. We're in the moment of a once-in-a-generation rewrite of the law. The last time the law was fundamentally rewritten was like 35 years ago. This is a quote from Simon Power, the previous Minister of Commerce who introduced this legislation. It's going through the system at the moment, and it's going to replace the Securities Act, and it's going to replace the current rules under that Act whereby cooperatives and industrial and provident societies issue shares to members and what disclosure those bodies must give to prospective members. Now, this doesn't really affect mutuals so much because my sort of rule of thumb definition of the distinction between cooperatives and mutuals is that mutuals do not have individualised ownership for each member. The whole mass of members might collectively own the organisation and control it, but there's no individual shares issued to any member. And so that's a key difference. And what I'm talking about now refers to individual shares, so it's less directly relevant to mutuals, but it is extremely important for cooperatives. Now, the basic proposal is that under the new law, this is going to apply to everybody. A PDS is a product disclosure statement, just a new term, marketing, and to replace an investment statement in a prospectus. And these are the key things that it's meant to do. And this is, as again, applies to investor-owned firms and to cooperatives as well. The real question is, what does this mean for cooperatives? And at the moment, under the current law, there is a set of rules that apply when investor-owned firms want to issue shares to the public. They've got to write very lengthy prospectuses and investment statements, and cooperatives have very significant exemptions from that. And the reason for that is that the Securities Commission has been convinced over the last 15, 20 years that when someone buys a share in a cooperative, they are not buying it for an investment return on that share in the same way they might be for a share listed on a stock exchange. And because they're not looking for an investment return, there is not, and in fact most of the time the cooperatives don't deliver a pure investment return, they're therefore returns on patronage, you don't need the full disclosure. And so that's why at the moment there is the status quo for cooperatives is pretty good, really, in terms of the amount they have to disclose, overhead, administration, that sort of thing. However, because the table is going to be wiped clean and we're going to start again, I know that over the next year or two, the officials are going to start looking at this and we're going to start again and have another look at what cooperatives should disclose. And there are a range of issues here. Cooperatives, when you buy a cooperative share, the traditional approach was you didn't get a return on that share. It's not traded on a stock exchange. You don't get dividends on it. Your real risk in buying the share in the cooperative at one level was the cooperative becoming insolvent and not getting your dollar back when you left. However, that's not really why people join cooperatives. They join for the trading benefits, and a lot of the time the trading benefits are described and the trading risks are described. If you're in international markets, there will be currency risk, all the risks that occur when you're doing business. And one of the fundamental questions is, when the new law comes in, what should cooperatives be disclosing as a matter of obligation to their members so they're fully informed? Should it just be the fact that they don't get their dollar back if the co-op becomes insolvent, i.e. an extreme event, or should it be the risk that they won't get the overall trading benefit, in which case it's a larger document? Current practice in New Zealand, well, the current legal obligation, one would say, is all you've got to do is talk about the risk that you won't get your dollar back. But in fact, there's a wide range of practice. Some cooperatives already have quite voluminous information where they explain the trading risks and benefits of the particular cooperative. So the real question is, what's going to be the legislative minima in the future? And for that purpose, at the moment, there is an opportunity for cooperatives to hold the pen, or at least try to hold the pen, and come up with what they think the disclosure should be, and put that before officials so that we can start from a good position. At the moment, under the old regime, what happened was the standard rules were put in place for investor-owned firms, and then cooperatives sort of had to, starting from that point of view, argue that no, we don't need this, we don't need this, we don't need this, we don't need this. So it's a sort of a strikeout from the list. And so the proposal would be, if we're going to move away from that, what should we do? And it's an opportunity for a ground-up review of how this overall obligation, which I don't think anyone would argue with, some of those words there, how that should apply to cooperatives. So the Cooperative Association is putting together a bit of a working party, and we hope that we can work with the officials as they work through this legislative and regulatory process to come up with a good package. At the same time, the Financial Markets Authority, the old Securities Commission, it's a new organisation, it's much bigger and broader and so on, is doing some other things. They are putting out a disclosure guidance note, i.e. how you should comply with the current law, and in a way they're trying to introduce this proposed clear, concise and effective principle over top of the current law. It's the principle and objective is fine. One can have some arguments about the legal technicalities, but that's the direction of where the obligations are going to go. And again, we are proposing some sort of interaction with the Financial Markets Authority on behalf of cooperatives to try and work out, well, what does that mean? What does it really mean, and what should it mean in the case of cooperatives? Part of that review, as I said before, there are current what we call exemption notices for cooperatives, which say that of the 45 things that you've got to have in a prospectus, 40 of them don't apply to cooperatives. That exemption is going to be reviewed. Probably will just be extended for another year or so while the larger work carries on. But for the purposes of just giving one issue out there of all the regulatory issues that are going on and affecting all of us, this is probably one which I think will have real importance for cooperatives, because onerous and prescriptive obligations produce compliance cost, make it difficult, and might swing the balance too far. So there's a good opportunity there. So I'll now take a breath and talk about an issue that affects cooperatives internally, that's special to cooperatives. And again, I think most of my emphasis is here on cooperatives rather than mutuals for reasons that will become obvious, I guess principally because that's what I know more about. The classic challenge for cooperatives is how and how much capital do you get from your members? As your cooperative grows and the value of it improves, how do you allocate that to members? And how do you return that capital to members when they leave? Now these at a high level, this will be common to every single cooperative. How do you deal with this? While at the same time maintaining cooperative principles, and this is my take on my observation of what they are in practice in New Zealand. Controlled by the active trading members, the people who are actually trading with the cooperatives. Distribution of rewards, profits in relation to the business transactions as distinct from dividends on shares. And also, traditionally, there's been a concept of transferring cooperative value to the next generation. So, I'm going to explain that a little bit more, but that's what I see the challenge has been, and over the time I've been familiar with cooperatives over 20 years, this is how I'd sum it up. Now, to be a lawyer for a moment, the Cooperative Companies Act is the framework for cooperatives grappling with that issue in New Zealand. And this was put through in 1996, and I was quite heavily involved with it. And it's a pretty small act, but I've sort of, in my view, stripped away at it all, and on one slide put down what I think really matters from that legislation. And the first is it's got some requirements. If you want to be a cooperative, registered as a cooperative, and use the word cooperative in your name, the principal activity of that organisation has to be trading with members. And 60% at least of the voting rights have to be held by your transacting shareholders. That's the people who are actively trading. And so it has some specific powers in it that companies, investor-owned firms, don't have. One of them is that co-ops can issue cooperative shares at a specified or fixed value, whatever it is, $1, $10, $100. It's in the Constitution, that's the decision. You don't have to issue shares at fair value. That's the general rule for under the Companies Act. Whenever you issue a share, the board has to say, is this value fair? You don't have to go through that process with cooperative shares. And the second thing that's unique about, from a technical point of view, is that when a shareholder ceases to trade and becomes, as they call them, a dry shareholder, there are a whole lot of rules about surrendering those shares, redeeming those shares is another way of putting it. So when someone ceases to be trading in shares, in certain situations that individual can require the cooperative to repurchase the shares, and in other situations it's the other way around. The cooperative can require the shareholder to sell the shares. In either case, it's a unilateral power. So why is that there? The surrender power is there, and you can do it on a case-by-case, shareholder-by-shareholder basis, to enable the company to make sure, the cooperative to make sure it hasn't got too many dry shareholders or too many people who aren't owning shares who are not trading with the company. So it's a power to enable the wealth and the control to be concentrated among the people who are actively trading with the company. That was what was put in there in 1996, and in fact that wasn't brand new in 1996, it was just carrying forward what happened, what was the position in the previous legislation. So I guess going back, the challenge is how do you deal with all of that while using the powers under the Act? Now, just to remind you, this is the traditional model as far as I understand it, going back before my time. The whole dollar in, dollar out idea. You put in $1, you took out $1 when you left. One vote per member. You got your return by way of milk price or rebates on whatever purchase you were doing, and the capital gain and the capital wealth stayed in the cooperative. Believe it or not, you know, when you think about Fonterra these days and how many hundred thousands of dollars that an individual farmer needs to have in Fonterra shares, some dairy companies, you know, 20 years ago, literally you just had to have $1. And, you know, companies like Western Dairy Company had like $300 of allocated capital, 300 shareholders each with $1 share. And so things have moved on enormously. But this is the traditional model. And the point about it, probably a key point, is that if it's $1 in, $1 out, or $100 in, $100 out, whatever the number, normally the price, when you paid that and became a member, that price was way, way, way below the relevant proportion of the real value of the cooperative. So it means you entered it cheaply in relative to its real value, and when you exited it, you exited at a low price as well, leaving a whole lot of value on the table. And that's the whole concept that, you know, you build a cooperative and it's the value of it transfers generation to generation. That's the traditional model in New Zealand, as far as I'm aware of it. So there's been change over the years. Whoops. It's all very well saying when you want to join, you just got to pay $1 or $100 or $500. Cooperatives need a lot of capital, or some as they grow, depending on what the nature of their business is. And they're not going to necessarily have all of it from retained earnings or from borrowing from banks and so on. The actual members need to contribute some real money. Secondly, members will have a variety of practices and of trading and differential levels of trade. And so there's been a trend so that if someone is trading twice as much as the neighbour, then they should put in twice as much capital, but also perhaps get twice as much reward and twice as much voting rights. And the other thing that's sort of been on the mind of cooperatives is that as the value of the whole enterprise increases, there's a risk and a tension that if you don't do anything about the entry price or the value that an individual shareholder has, the proportion that value represents to the value of the whole enterprise the gap could get bigger and bigger and bigger. And that's, in a way, a problem of success in the sense that the cooperative is growing and being profitable. So these are factors leading to change, and there have been various responses in New Zealand. These are what I'd call some traditional responses. The entry price, the $1, goes up. That's to get some more capital out of people when they join. There's been a much more of a trend to having proportionality of voting and capital contributions in proportion to trading. And also, even though you might put in your dollar, there's been a recognition that as the value of the cooperative increases, some of that value should go back to the members over time, not just by way of a higher price or a bigger rebate year by year, but an increase in the amount of, or the value of the shares they hold, so that when they leave, they might have put in $1, but they get back $2. And so there's various ways in which that's being done. Now, the more you do that, the more you create what everyone will have heard about, the bogey of redemption risk. Now, redemption risk with cooperatives is the inevitable outcome of the fact that when you buy a share, you're buying it from the cooperative, and when you leave, the cooperative is buying it back from you and paying real money. Now, the greater the value of the shares that the cooperative needs to repurchase when you leave, the greater the risk to its balance sheet. And that's termed redemption risk. And by reference to my next speaker, that appears to be one of the very large motivations behind the Fonterra's Trading Amongst Farmers proposal. So redemption risk is a real key issue. So how's that being dealt with? You know, it's one thing to increase the value of shares, give people bonus shares, but that means you've just got to pay more money to them when they leave. How do you respond to that risk? And again, there's been a range of responses. Hybrid cooperatives are a classic. This is where cooperatives issue two classes of shares: investor shares, that's Companies Act shares, and the traditional cooperative shares. Investor shares are just tradable amongst individuals, that you don't trade them with the company. So to the extent there's any value, the value is what you can persuade someone else to buy them from you at. There's no right or obligation for the company to buy the shares back from you when you cease trading. On the other hand, a hybrid would retain cooperative shares, and they're not traded, except maybe when one farmer sells the farm to another farmer, the parcel of shares might be traded, but otherwise they're not traded on any market. And there are a variety of ways in which this has been done in New Zealand. For example, Livestock Improvement Corporation, a cooperative, it has two classes of shares. All the votes are with the cooperative shares, and the votes, again, is traditional based on your level of business. But they've created a separate investor class of shares, and those are the shares that get dividends, and those shares are traded amongst the membership, and the price rises and falls, and the members get their benefit that way. And the purpose of that was to unlock some of the retained value in the company, but do it in such a way that the company didn't have to pay out that value, that the shareholders would trade it amongst themselves. Other examples, there's a kiwi fruit cooperative called Satara, and it's got 60-40, 60% cooperative shares, 40% investor shares. Its investor shares are you can purchase on the share market. So any of us could go and buy shares in Satara as a hybrid cooperative. Interestingly, the issue of those shares so far has been only to, in effect, allocate existing value in the company. They haven't been used. No cooperative, as far as I know, has gone to the share market and said, here's some investor shares, what will the market pay? So we haven't reached that stage in New Zealand yet. Now the next one is cooperatives without cooperative shares. Now we've got, I know some people in the room here from two cooperatives which are heading in that direction, Fonterra and Silver Fern Farms. And I think it's a trend, and I see the chairman here would be able to correct me, but they're moving to have what's called ordinary shares as opposed to cooperative shares. Those ordinary shares are traded on the unlisted share exchange, and there's no obligation to surrender them back to the company. And the purpose of that is to remove redemption risk. Similarly with Fonterra, if trading amongst farmers actually happens, then those shares will no longer be redeemable by Fonterra. They will not have the redemption risk, and the farmers will get their value from those shares when they buy and sell them between each other. So, and both of those cooperatives would remain cooperatives, because the key requirements being your principal activity trading amongst your members, and secondly, 60% of the voting rights with your trading members will be satisfied. And neither of them would feel the need to use those special tools that I mentioned, having a cooperative share and the surrender and redemption obligations. They're able to ensure that the two overall requirements are met without using those specific tools. So that's an evolution that probably wouldn't have been anticipated 20 years ago, but our legislation permits that. So ultimately what that means is under our law we've got huge flexibility to be a cooperative, and it accommodates all these models. It means that there's interesting challenges. If you've got trading shareholders and dry shareholders, how do you manage their respective rights and interests? If you've got different classes of shares, how do you manage those respective rights and interests? And if you're giving rewards based on level of business, and at the same time some returns on shares and investments, how do you manage that balance? So that's the end, except one slide on mutuals, which is simply that the thing that occurs to me about mutuals is that if they've got lots of members and they are all members but in an aggregated mass and they don't have individual share rights, the big challenge for mutuals is to get their members to realise they're owners and not just customers, and to realise they control the company in a collective way. Because if they don't, then, and they see their company as just a provider of the service, then You wonder what the actual nature of the mutuality is, and I would say that's an ongoing challenge, but a risk if it's not met properly. So that's a very quick gallop through, and we'll have questions later on after John's spoken.